attending the Dr. Gordon Wachowski Law Foundation of Saskatchewan Chair in Police Studies lecture. The title of today's lecture is Beyond the Criminal Law: What Local and Provincial Authorities Can Do to Regulate Sexually Oriented Business. Before I make a few introductory remarks regarding the lecture series, I would like to welcome some special guests. With us today is Mr. Kevin Fenwick, the Deputy Minister of Justice and Deputy Attorney General of our province. With us also is Chief Rick Rossa from the Moose Jaw Police Service, and I'm particularly honored to welcome Dr. Gordon Wachowski, after whom his lecture has been named. And I would like to tell you a little bit about this lecture series and its history. The Saskatchewan Law Foundation is dedicated to, quote, enhancing legal education and research in order to respond to the challenges facing the administration of justice. And through the Foundation's generous support, we have been able to establish the Saskatchewan Chair in Police Studies. And this chair, to me it seems that it was established a year or two ago, but it's almost 10 years. And that speaks to not only the importance of the goals that we are pursuing, but also to the generosity of the Law Foundation. These studies, the studies of the Chair in Police Studies, support the Foundation's goal to examine contemporary issues in policing and social studies. They also help to address the concerns of the Aboriginal community and to recruit more Aboriginal people into policing. And each year we have an event like this. We have a lecture of a prominent scholar or practitioner in social justice or in policing, and that lecturer addresses issues of direct relevance to policing and social justice. And now I would like to ask Dr. Carlos Nandonio to come up here and introduce our speaker tonight. Thank you very much.
Good evening, everybody. My name is Carlos Nandonio, and I am from the Department of Anthropology here at the University of Regina. And I must confess with some chagrin that my Department of Anthropology was not asked to contribute funding for this event, and it's really sad because it would have made us look good. Our speaker today is Mariana Valverde of the Center for Criminology and Sociolegal Studies of the University of Toronto. Professor Valverde received her PhD from York University in 1982, taught briefly at Trent and York Universities before joining the University of Toronto in 1993. She is a Fellow of the Royal Society of Canada since 2006. Professor Valverde's main research interests are urban law and governance, which she examines through lens shaped by her engagement with Foucault, Bakhtin, sexuality studies, theories of spatiotemporality, and actor network theory. I believe she's about to take up again an old project of hers, working on urban regulation in New York City and London, addressing legal and policing tactics that produce and reproduce distinctions between good and bad neighborhoods. She's also got rich SHRC funding for work on public-private partnerships. Now comes a good part, which is where academics are most impressed with this bit. She has 6 sole-authored books under her belt, published by the University of Toronto, Chicago, Stanford, Ralph Lynch, and Princeton. For those of you who are not academics, when we academics hear that somebody has published that much with those presses, we start treating them like aristocrats. She has also published 6 co-edited collections, about 50 refereed journal articles, and various research reports and popular publications. 2 of her books have won the Law and Society Association's main book prize. Now, I list these metrics with some trepidation because the website I harvested that information from is about 2 months old, and at that prodigious rate of production, she might have a few more articles out. I think there's a book out as well, right, recently?
Well, it's not out till January, so.
Oh, it's not out till January, so let's not count it. She has a distinguished history of effective action and leadership in the areas of feminist and gay rights activism and law, with several presidencies and editors-in-chiefships of prestigious journals that I won't go further into right now. I urge you to Google Mariana Valverde on the web, and you'll see what that's about. Her U of T staff website page is riveting reading, very intriguing. And before I do the whole without further ado bit, I am inexorably called to read to you one line from her website. In her bio, she says, right at the very bottom, "Finally, I am not on Facebook, Twitter, or LinkedIn, which gives me time to read newspapers and novels." So suffice it to say, it is our privilege tonight to have with us a wise person, as well as a scholar of great substance. So if you would welcome Mariana Valverde.
Well, thank you, Carlos, for that very kind introduction. Is the sound okay for the, okay, good. And I really want to thank the Law Foundation of Saskatchewan, as well as the university, for inviting me here. We need to have a lot more conversations about the regulation of sexually oriented businesses. It's not a topic that a lot of people want to talk about, but it's hugely important. And I think those people who are at the sort of practical level, whether they be women who work in the business or whether they be law enforcement people, know how important the issues are. So I hope you will go on and talk about it with other people, and that this won't be the last discussion of its sort. I want to start with this picture simply to underline the fact that while Parliament is contemplating a new criminal law, there's actually already all kinds of businesses, some of them are licensed businesses, where sex is being sold contrary to our current criminal code. So there's already a lot of sexually oriented businesses that exist. I recently heard, and it was just yesterday, so I didn't have time to check it out, that in Saskatoon, escorts are licensed, or escort services are licensed. If anybody has information, I'd love to hear about it. So I start with this because I think there's a big disconnect in terms of some people just thinking, well, should we have this law or that law? At the federal level, at the level of the criminal law, and they don't realize there's a lot of stuff going on that has to do with municipal licensing and the kinds of topics that very few people take an interest in. Okay, so just very quickly, I think everybody knows that the old laws, or most of them, were struck down in 2013 by the Supreme Court, and the main reason for it is that it was found that the laws cause additional harm to the women in the business. Now, what we haven't necessarily thought a lot about as Canadians is the fact that appealing to courts to strike down laws has its disadvantages, even though that's how things have proceeded in terms of same-sex marriage and a lot of other things, right? There's been a lot of countries where, without pressure from the courts, legislatures have thought about the issues and have written new laws. Sweden is an example, I'll talk about it in a minute. The Netherlands, a very different criminal law. New Zealand, yet a completely different criminal law. I think when legislatures think about things that are from scratch and without the pressure of a court having struck down a law, perhaps you get better law as a result. But in Canada, there hasn't been real pressure on the political parties to think about this issue. I've been active in this issue ever since the early 80s. And I think what happened is that in 1985, we had this Fraser Committee on Prostitution and Pornography, and some of you who are as old as I am might remember it. It was like a royal commission, even though it wasn't called the Royal Commission. It came out with many recommendations that were quite sensible. They were completely ignored, not only by the government of the day, but by every government since, and by every political party afterwards. So activists who wanted to change the laws because they realized they were not working particularly well, basically gave up on Parliament, gave up on the political parties, and pursued the constitutional challenge route. And this eventually was successful. But as I said, it poses a problem. What the activists that I know wanted was for the court to just strike down the laws and have a kind of Morgenthaler, situation. With the Morgenthaler decision, the abortion law was struck down. No new law has ever been passed. The sky hasn't fallen. Sort of somehow everybody's got used to it. And so a lot of the people who were advocating for law reform just thought, well, let's just get rid of the old laws, go to court, get that happening. Parliament will never be able to come up with a new law anyway, so we don't have to worry about a new law. Well, guess what? There happens to be a majority government now. If there wasn't, you can be sure this wouldn't be there. And so a new law is happening, but it's happening without the party in power having particularly wanted to change the law or having particularly thought about it, at least as far as I know. Okay, just a little bit of philosophy before we get on to the practicalities. When you're rewriting old laws, when you're rewriting laws that everybody knows are old-fashioned, Victorian, whatever, what do? How can the regulation of morals be made compatible with the Charter? Well, as many I'm sure most of you would know, the Supreme Court of Canada has decided that the way to do this is to say that the harm principle is more important than offense to morals. So the obscenity law was rewritten in 1992 in the Butler decision with risk of harm as the new test of obscenity. And a similar thing happened with indecency law, which has changed quite a bit, again, to promote the harm principle instead of offense to morals. However, back in '92, when the Butler decision came down on obscenity, I think people didn't realize that it wasn't so easy. Switching to a risk of harm principle didn't actually solve the problems, because you had to decide harm to who and to what, and who is counting the harms. So what we have now is a situation where everybody agrees, yes, if we're going to recriminalize prostitution, it has to be because of the harm principle. But there's absolutely no agreement as to whose harms count the most and who is the authority on harms. Because the sex workers will tell you they're the authority, not the neighbors who complain about the nuisance, or not the police, whatever. So, I mean, there's a wonderful article by the noted criminal law theorist Bernard Harcourt, The Collapse of the Harm Principle, and I often think the Canadian Supreme Court is the best example of that, because there's great agreement on the harm principle, but what harm means and who is supposed to be the judge of what harms count is not at all clear, and that, as I said, goes back to the Butler decision. Now, the harms of prostitution are laid out as is usual in the whereas sections, in the whereas clauses of the new bill. And it's always worthwhile reading the whereas clauses if a bill is not necessarily straightforward. So there's two claims that are made in the whereas clauses, made as factual claims that a lot of people would agree with, but a lot of people would disagree with. And yet these statements are made as facts that everybody knows. First of all, in the first one, the exploitation that is inherent in prostitution. That's sort of made as a factual claim. I'm sure many of you know that many people say, well, some forms of prostitution are exploitative, but if you're running an escort service and you're making a lot of money and the only other job you could get is minimum wage, it's not so bad. And in any case, the point is that there's no general agreement that all prostitution per se is necessarily exploitative. Especially when you say, well, as compared to what? Sort of given unskilled jobs available to women. And then the other one is the one at the bottom, the other one I want to highlight. I mean, all the other ones would be worth discussing. We could sit here for 2 hours having a seminar on what are the assumptions about human beings and sexuality that are there, but we won't do that unless you want to come back to it in the question and answer period. I'd be happy to go back to the slide after if you like. But the interesting clause is the one at the bottom. It is important to denounce and prohibit the purchase of sexual services because it creates a demand for prostitution. Well, I mean, it's actually the demand that creates the purchase, but anyway, apart from the slight logical problem. The point is that targeting demand, right, is supposed to be the main thing about this new law. Now, targeting demand sounds like a new feminist idea, but it's in fact a really old idea. The international movement that is interested in targeting demand for sex work calls themselves abolitionists. And it's an interesting word because they draw quite consciously on a parallel with the old 19th century anti-slavery movement. And slavery was largely abolished, at least legal slavery was abolished. So they think that you can abolish prostitution the same way that slavery was abolished. And whether that analogy holds or not, I think is a question. In countries that have targeted demand, you know, Sweden being the main one, in a fairly hard kind of way, in fact, prostitution has not been abolished. But many of the abolitionists that I know basically are interested in that bit, the denouncing bit. So what they say is that, well, even if prostitution isn't abolished, it sends a message to say that it's the demand for prostitution that is wrong. Now, there's a long history of this. So in the early 20th century, as some of you may know, there was a big movement against what was then called white slavery. And white slavery then was what we would now call trafficking. It was part of a fairly racist kind of panic about foreigners taking good Canadian white women and shipping them off to brothels in Buenos Aires and so on, which proved to be quite without any empirical basis. I mean, there was definitely sex trafficking, but not in, you know, Winnipeg and Toronto, which is where the agitation was happening. And this was part of a movement, a very kind of utopian feminist movement, best represented by the English you know, suffragettes' slogan, "Votes for women, chastity for men." And she was quite serious. I mean, this was not a joke. This was her platform, votes for women, chastity for men. So she really thought that as women got empowered through the vote, they would have the power to really change men and make men no longer want to go to prostitutes. So here's, Christabel Pankhurst, and there's our own Nellie McClung, who is also an abolitionist, though not necessarily calling for law reform in the same way. Okay, so now back to the present. Here's some highlights from the bill. And I should just say I'm not a lawyer, and I know quite a bit about this area of law, but I'm not giving a legal opinion, so just a caveat. So first of all, targeting demand, all offers to buy sexual services are criminalized. It's a summary offense most of the time, but if you're, I can't remember now, if you're within X meters of a church or a school, then it becomes an indictable offense. Now, any of the police officers in the audience would think, well, this is an enforcement nightmare to figure out if it's indictable or summary by taking out your measuring tape. Anyway, and then it becomes even more difficult because sex workers themselves, even though in the whereas clauses are talked about merely as victims, here they appear as offenders. Basically, if they advertise anywhere or if they, sort of put out a sign or anything like that. And then the other clause is basically the old living on the avails clause, but sort of slightly updated. Everyone who receives a financial or other material benefit and so on. Now, as I read this, this would mean that a woman who's running a very high-end escort service where the women are treated well would be liable under this clause, and it's an indictable offense. So as I read it, at least, it's basically the living on the avails law, which was thoroughly critiqued by the Supreme Court by saying that, women weren't allowed to hire receptionists and hire drivers or hire security, and so the living on the avails law had to, go because it criminalized anybody who was involved in facilitating sex work. Now, where did the law come from? So Peter MacKay, made a statement and he said, this law is made in Canada. Well, actually not. It was sort of made in Sweden with a few extra additions. Now, there is an international consensus. And I think you can see this everywhere except the US. The consensus is that the old prostitution laws, based on public order and morals, like the ones that were struck down by, by the Supreme Court, are outdated. And there's also a consensus, I think, across the political spectrum, that dangers to women workers are the main thing that should be addressed as opposed to offense to morals. But then some will argue that all sex work is inherently exploitative, whereas a lot of other people will say, well, no, under certain conditions it's exploitative, and if it's criminalized and it has to go underground, it's going to be even more exploitative, and if it's legalized, it can be okay in certain circumstances. So, the disagreement ends there. Now, European countries, Western European countries, I should say, have basically all changed their prostitution laws quite radically over the past 10, 15 years, but in very different ways. It's actually a case that goes completely against the idea that the EU is sort of harmonizing all their laws. Like in terms of prostitution, there's extreme policy divergence. But one of the things that's common is that part of the move for changing prostitution laws is the fact that, that with the expansion of the EU into Eastern Europe and with the fall of the Soviet Union, an awful lot of unskilled women from Eastern Europe were going into Western Europe looking for work, whether it was sex work or other kinds of work. That is the sort of demographic reality that really sort of prompted a lot of the law reform. But as I said, EU countries went completely different ways. And I think this is something that isn't known in Canada. I think a lot of people have heard about the Swedish approach, but they haven't heard about what's going on in Germany or Spain, which is quite different, which is full legalization. And then in the Netherlands, which, as you probably know, has long had legal prostitution, although highly regulated. In the year 2000, there was a new criminal law passed that really, really seriously went after exploitation, but it distinguished between exploitation and sex work. And so it allowed for voluntary sex work under decent working conditions while going after exploitation in a fairly hard kind of way. And I do think that we should be looking at all of these different laws and not just the Swedish one. But the Swedish one is the one that's most influenced the current bill before Parliament, so let's talk about it for a minute. This law came out of, it wasn't just a prostitution law all by itself. In 1999, the Swedish Parliament passed this kind of omnibus bill called the Women's Peace. And it criminalized a whole lot of behaviors that weren't criminal before, including what we would probably call sexual harassment. Some of you may know that Julian Assange is liable to being prosecuted for some kind of sexual offense if he were ever let out of the Ecuadorian embassy. But the Swedish government has charges against him, and that's under this Women's Peace. So the behavior that he is alleged to have committed is something that would not have been criminal before. Anyway, so there was this Women's Peace, and that's the context. A big sort of feminist-driven reform of the criminal law. And in Sweden, abolitionism, which I talked about, the targeting of demand, is totally what the feminists who are social democrats believe. And I think it's a really interesting contrast with the Canadian NDP, because in the Canadian NDP, you have every point of view on prostitution. So you have some women who are abolitionists and some who are completely in favor of decriminalization. But in Sweden, they had more of a sort of coherent strategy. And as I mentioned before, unskilled Eastern European women moving into Sweden was a big part of the fear. So the fear was that they were being trafficked, or even if not trafficked, they were being exploited in sex work. Though, of course, they were also being exploited in a lot of other under-the-table jobs, which drew a lot less attention. Now, the Swedish law has a very interesting provision, which the feminists in the audience would be interested in. It specifies that the exchange of sex for material benefit that's criminalized has to be short-term only. So when I was reading this, I thought, well, why short-term only? And then I thought, aha. Because what they're trying to do is prevent men, rich men who marry young, blonde, third wives or whatever from being charged. So it's the gold digger marriage that could have been criminalized if they hadn't put in short-term. And I think that raises some interesting issues about defining what counts as the exchange of sex for material benefits, which we can leave for the discussion. Now, the Swedish law has a little escape valve, which is that it's okay for women to work in their own home, but only if they own it. And in Sweden, being a social democratic country, the vast majority of people live in rented housing. So not that many women own their homes. But I don't know why there's a property owner's exception. I mean, all these laws are more peculiar the more you look at them. Now, the Swedish government was not at all keen to have external independent studies done of the effects of the law. They really kept researchers away, and the main studies that exist were done, when you look at the author, it's the same woman who drafted the law. It's like, okay, well, I mean, wouldn't it be nice if people who draft the law get to do their own evaluation? Anyway, some studies have been done, although very partial. And what they show is that there was indeed a decrease in visible street work, not surprisingly, because men were afraid of being charged. But those women who were still on the street were suffering greater harms and risks. And in one study that I read, one of the women interviewed said, wow, now you only get the weirdos out on the street. Before you got ordinary guys. Now you only get the weirdos, which was kind of an interesting comment. Anyway, it's definitely true that if you criminalize the customers, then the workers go underground too. They may not be criminalized, but they're not able to openly have a business and openly sort of carry on with what they're doing. And the Swedish model has been extremely influential. It was adopted in Norway, even though the Norwegian government's own report counseled against it. It was adopted in Iceland. It's been also adopted in France, I hear, though I have very little information about this. And the Scottish government has reformed their own law so that it's similar to the Swedish law. And I don't have as much detail on that as I'd like. So now we get to sort of the real point of the lecture, which is sort of the limits of any criminal law. It's very clear that none of the, oh, there should be an E. No, it's not non-existing criminalization. So, this is, so none of the existing criminalization systems can really tackle exploitation. I mean, I think that's well, proven. Now, when you decriminalize, you do avoid some problems because the underground economy causes its own problems. In Germany and Spain, which have decriminalized, completely, you have a lot of legal businesses run by ordinary business people, and there seems to be less organized crime. On the other hand, the working conditions seem to be quite bad in most of the legal brothels. So it's by no means a great solution. Now, the question then is, are the harms that are associated with prostitution, are they really targeted by any criminal law remedies? And that's not a question I think that anybody can answer, but it's a question we should be asking. Is the criminal law, either the old one or the new one, is it really going to do anything in any substantial way to remedy the conditions associated with prostitution for a lot of women? And certainly the research that's been done on this, I've read an awful lot of it. One of the main things that the research says is that if any government thinks they can eliminate street prostitution by legalizing brothels, they are dreaming in technicolor, because street work is quite different. It's a different market. It's often different women. It's often just sort of short-term, whether it's driven by addiction or extreme poverty or whatever. But you cannot get rid of street work by legalizing brothels. It doesn't work like that. They're not necessarily the same people. And certainly, immigrant women, Aboriginal women, especially when they're not living in with their families in their communities, are absolutely vulnerable. But whether any criminal law can really help that, is a big question, because the research is not very hopeful that any system of criminalization is going to help. Now, what about beyond the criminal law? Well, I'll just quickly run through some of the efforts that have been made using provincial jurisdiction, because provinces have for 30 years at least tried various ways to sort of regulate prostitution using highways, traffic laws. But courts have often struck these down because obviously the jurisdiction of the provinces is limited. At one point, injunctions were very popular, but those were usually struck down by the courts as well, because the injunctions were really infringing on the jurisdiction of the federal government in criminal law, because they were targeting prostitution, and the courts would say, well, you can't do that. You don't have the power to do that. Now, some provinces have done stuff that is within their jurisdiction, and which is probably more sensible, which is to have laws that allow for buildings to be closed by judicial order if safety concerns arise, and that's much more realistic and practical. But I think the point is that if sexually oriented businesses are not legal at all, it's very hard for the provinces to use their usual sort of consumer and business regulation mechanisms to regulate them. I mean, you can't use either public health or labor and employment laws for underground illegal markets. I mean, you can try, because, there are sort of public health regulations that apply to massage parlors, but as I'll mention in a minute, that's only using the legal fiction that what was on there is really only just massage. So just a couple of pictures of legal brothels. I really like the picture on the left because 99% of pictures of brothels are kind of reproducing the old Nevada stereotype of the woman, you know, and like here's an actual guy, like one of the customers, and his face, of course, is obscured by smoke, but I think, well, we should have more pictures of the guys and fewer of the women. Okay, so public health, I'm getting to the end here. Now, there's a long history of public health authorities somehow regulating sex work, even where sex work was not legal. And by and large, public health authorities do not have a good reputation with sex workers, unfortunately. I mean, there are exceptions to that. There's some public health workers in both Vancouver and Toronto who have worked hard to build good relationships and who are doing a good job. But in general, you mention public health to sex workers and they go, oh no. And there's a good reason for that historically. And even in the present. I was looking at regulations for brothels in Nevada. And they are just draconian. It's like charter rights don't exist or something. So the way women sex workers are regulated is just beyond belief. First of all, the brothels impose certain shopping hours, so the women can only leave the brothels at certain times, like Saturday between 2 and 6 or something. And so there's a sort of general system of control of women, and the women have to have not only blood tests, but physical inspection by doctors on a very, very regular basis. The customers are never tested. Anyway, and this goes back to 19th century Paris and the whole system of medical police that was incredibly intrusive. So there's a very long history of public health being used in a kind of stigmatizing and demeaning way. And as I said, there's a lot of, I mean, I have a lot of friends who work for, you know, Toronto Public Health, whatever. I mean, public health now is not what it was. But there's a bad history there, and I think we have to take that into account. And I think in terms of public health, the places that are likely to have good approaches to regulating sexually oriented businesses are the same kind of places and people who are, you know, coming up with harm reduction strategies for HIV and injection, you know, drug use. I think with HIV, a lot has been learned about how to use public health positively and not to sort of scare people away and, you know, so on. But the harm reduction approach, of course, clashes with the premise of our bill before Parliament, which is that prostitution is inherently exploitative. What about municipal jurisdiction? Well, municipalities have a lot more, you know, jurisdiction over most things related to sexually oriented businesses than any other level of government. They, of course, have jurisdiction over nuisances, and, you know, some municipalities have been very clever. You know, if there were Johns driving around streets in a particular place, they would change the traffic so that there were all these one-way streets going the same way, and like the Johns couldn't drive around anymore. You know, which is probably a creative and inexpensive way to sort of at least alleviate the problem. But of course, the municipalities are not able to target prostitution in a direct way, and neither can they regulate it in a direct way. I mean, back in the days of the Fraser Committee in the mid-'80s, some of the big municipalities were really advocating for licensing and zoning powers, but they, of course, you know, can't have those as long as the criminal law is in place. Now, where sex work is legal, zoning has been used extensively to regulate it. All over Australia, in most Australian states, prostitution is legal. And zoning is used in different ways, you know, to make sure that the businesses are in appropriate areas. And of course, zoning is already used in Canadian cities in respect to adult entertainment parlors and massage parlors and so on. Now, zoning sounds like a good way to regulate businesses, whether they're, you know, massage parlors or whether they're brothels. But what you often get is municipal politicians who are being talked to by their respectable constituents, and you get the sort of NIMBY syndrome, and then you get municipal politicians who say, well, it's all right. I mean, if brothels have to be legal, that's fine, but I don't want any in my particular ward or in my district or, whatever. And municipalities often come up with zoning schemes that basically mean that you can't possibly find any property in that whole city where you could possibly legally put a brothel. And one of the things that's interesting about this is that in Australia, there's been all kinds of controversies with all kinds of municipalities having very, very restrictive zoning and licensing, such that they're essentially driving it out of their area completely. In the suburbs around Sydney, that's been happening. And in New Zealand, some municipalities, after prostitution was legalized, some municipalities tried to kind of zone it out. But courts struck this down because they said, well, we have a law, and the law says these are the principles for regulating prostitution, and you can't sort of use your municipal powers essentially to kind of have a backdoor recriminalization. So, the New Zealand example shows that when you have a law that's been carefully thought out, passed through Parliament without the pressure of the courts, striking down the old ones, you can get a sensible system, and the system can withstand the sort of pushback from the kind of municipal politicians who exist all over the world, who always imagine that in their area there's no rooming houses and there's no sex and there's no nothing. Okay, so apart from zoning, the other main municipal jurisdiction is licensing. It's important to know that there's not just one type of license. It's very important to know there's different types of municipal licenses. There's a generic business license, which is, at least in Toronto, what variety stores have. And in New Zealand, which is probably the best system, brothels have a generic license. So it doesn't say anywhere, sex sold here, it's just a business license. You can have a specific business license, and obviously restaurants have specific, licenses. And then you also have licenses for persons, which are essentially not for persons, but for trade. So taxi drivers have a municipal license, in addition to the car being licensed. And in many municipalities in Canada, massage parlor attendants, strippers, and escorts are already licensed. Now, this is what people do not know. The vast majority of Canadians do not know that you can actually get a license for a lot of these things. And I think knowing more about this would be quite useful when we're thinking about the criminal law. A study of licensing in Toronto, interestingly, showed that the same woman went from a massage parlor that was licensed, where the working conditions were really bad, to unlicensed escort work, where the work was much better. I'm not necessarily saying it was because it was unlicensed, but it did show that maybe licensing isn't all that good. And in fact, in Toronto, the process of getting a license for working in a massage parlor or being a stripper is quite demeaning and stigmatizing, and you get a personal license that has your picture, just like a taxi driver. It's not particularly useful to force women to go to City Hall and pay their $200 or whatever to get their license that says adult entertainment, whatever. Like that is not realistic. That's not what people want to have. A generic license would be a different thing. Now, one of the reasons for licensing is to allow the police entry without any kind of warrant. So the police can go, as you all know, they can go into bars and do a license check, a license inspection, only because the bar is licensed. So if you have a university residence and it's not licensed, they can't go in. I mean, you could, of course, be selling beer, but because you don't have a license, the police don't have the right of entry. And sex workers have often said that the licensing of escorts and massage parlor attendants and strippers opens then the door for the police to be constantly harassing them and constantly going into those premises and asking them for their license. In fact, one sex worker that I was interviewing said, well, I was stripping, and then this cop came in the bar, and he asked me for my license. Well, I wasn't wearing any clothes. Where would I have my license? And of course, he totally, you know, interfered with her money-making opportunities because she had to stop everything. And of course, the customers weren't thrilled to see the cops, so drives out the customers, and then she has to go to her locker and get her license and, you know, show it to the cop. So the experience of licensing is not necessarily a positive experience, which is why licensing, even though it's touted by a lot of people as the great remedy, is often unpopular. Now, the state of Queensland in Australia is one of the many Australian states that has a prostitution licensing authority, and it's actually called that. So, you know, just to see these things are possible. But in Queensland, they have a very unrealistic system. The license fees are way too high, and the conditions are far too strict. So basically what's happened is that they have licensing, but they might as well not have had it because the vast majority of businesses are underground and they don't bother to get a license. And I have this quote here that's quite good about how, I mean, it really shows if you impose conditions that are way too strict, it's not going to work. And if the conditions, if the licensing system isn't realistic, it's not going to work. And it's just going to drive the business underground. Anyway, so I quite like that quote. I think it's, it shows that even when you legalize, you know, sex work, you can still have all kinds of policy problems. And then the final point here is that for municipal licensing to happen, of course, you have to have this legal fiction that no sex is actually being sold. So you have to pretend the massage parlor is just for massage and so on. And so there's all kinds of places in Toronto that everybody knows actually are selling sex, but they can't give out condoms because then the legal fiction would be sort of blown and it would be clear that sex is going on. So in fact, I mean, it's completely contradictory. It's a crazy system because the women who work there have to have HIV tests, but on the other hand, if there's a bunch of condoms there at the desk, then the licensing inspector or the police will say, aha, sex is going on here, so you're not really doing what you're supposed to be doing according to the license, and then they can get in trouble. So one question is, in regard to the new bill, could a business advertise safe sex or an individual woman advertise safe sex if the customers cannot legally buy it? Or are we still in the realm of legal fictions? So, what's the policy scene? I don't think it's very hopeful. The current bill, as I mentioned, is based on abolitionist premises that are at the very least, you know, debatable. And what's really interesting is that the two major studies that have been done very recently of the practices of the Vancouver police, and the practices of the Vancouver police are de facto what the bill before Parliament is. So the Vancouver police have been told, only charge Johns, never charge the women workers. That's what they've been doing. So two studies were done to see whether this really helped a great deal. And you can read the studies for yourself. The British Medical Journal one is very interesting, and it's open access. Anybody can read it. You don't have to be an academic to go online and get it. And it shows that it doesn't actually help. I mean, it doesn't hurt the women. Obviously, you know, it was worse before when the women were being charged too, but it doesn't actually help. And another independent study that was done of the same thing, also using Vancouver, also showed that it didn't help the women at all. And I think it's important to have these two studies of a jurisdiction that's already doing de facto what the federal bill is sort of trying to do. So the only kind of policy alternative that has received anything like a lukewarm endorsement, I guess. I mean, I think in this realm, you're really talking about the least bad of the alternatives. You're never talking about, really good, is the New Zealand system. And that's what's promoted by the Canadian Alliance for Sex Work Law Reform. I think with the New Zealand law, the process is as important as the outcome. And the process was that the Labour government sat down with a fairly powerful national sex workers organization, which unfortunately doesn't really exist in this country. And they worked out, and the police were involved too, and public health, all these people were involved. But the sex workers were a stakeholder just like the police. And they came up with a system that legalized brothels but didn't make them mandatory, so it didn't pretend that street work would disappear as soon as brothels came into existence. It didn't try to criminalize street work. And I think the key was that only mid-sized and larger businesses in New Zealand are licensed. And it's a business license, it's not a personal license. So the women never have to get a license. The women don't have a little card that says, sex worker or anything like that. The women work there just like you can go and work in a restaurant without having any kind of license. The business has to have a license. It's the same thing. So if you have 4 workers or less, then you don't need a license. And that seems to be working as well as anybody can expect. And there was a 5-year evaluation done in 2008 that's available online from the New Zealand Ministry of Justice, and it does seem to be working well. Why? Well, first of all, it incentivizes employer compliance as opposed to the state of Queensland system, which seems to be designed to, for show only, for sort of symbolism, but really there's no incentive for employers to comply. And then the sex workers, remain key actors, and they were key actors in the evaluation, which I think is really important. And then the final point I'll already mention, but I'll highlight it again, is that unrealistic local licensing schemes are not allowed, basically by law, because courts have said, okay, if a municipality tries to kind of zone it out, that's not allowed. Because you're not allowed to exclude sex workers from your community. That's part of the bill, part of the national law. And sex workers being included as part of the community rather than a threat to the community is certainly a key point. So the last slide. What should we do? Well, in thinking about this, unfortunately, I think it's a situation where we need to think both about the minor little details of municipal licensing that nobody except me knows about. I'm the expert on municipal zoning and licensing. None of my law school colleagues ever want to hear about it. They're so keen on constitutional law principles. They couldn't care less about business licensing. Well, you need to care about the details. I hope I've shown that. But you also need to care about the principles. Care about why are you regulating or criminalizing something? What is the basis of that? Is it because the community is offended to see sex workers on the street? Is it harm? And if it's harm to what and harm to whom? And should all harms be addressed in criminal statutes? I mean, in 1990, the Supreme Court said in the prostitution reference that the harm of nuisance that was, proven to exist because of street prostitution was enough of a basis for a criminal offense. And I thought, well, in that case, why don't we criminalize noise and we criminalize all kinds of other things? So whether all harm should be addressed in criminal statutes is a question. Who are the stakeholders? What kinds of regulatory models, can we look at? And I think certainly the alcohol regulation field is a really interesting one because Canada has a long history of regulating the risks associated with drinking, and we could learn something from that. And then finally, as I said, the devil is in the details because regulations can undo good laws. So it's a really complex business, and as I said, it involves everything from philosophical principles to the most minor details. It's very complicated, and we haven't been talking about it enough. So I just want to end with that slide. Okay, so thank you. I'm sorry I've gone on so long. All right, so should I take my own questions or, okay, yeah, whatever. I don't know if you want to put the house lights up or not, or.
So, please, fire away with your questions.
Yeah.
Already on the streets. How is that improved by the legalization of brothels?
Okay, so the question was about the New Zealand law and particularly about street workers. I don't think their situation was particularly improved necessarily by the law, except that if neither them nor their customers were liable to criminal charges, they could be in safer places. So they didn't have to sort of go to the back of the parking lot or an industrial area or something. But the main thing is that street work, in other places that have legalized prostitution, street work has been criminalized. So there's quite a few places in Australia where the police will say, well, it's legal to have a brothel, so we can arrest all of the women on the street. Not realizing that actually it's not necessarily the same women, and some of the women who are on the street aren't going to be applying for jobs and working at a particular time of the day, and I mean it's just a different sort of kind of population. So the problems of street workers are not going to be solved by any law, but at least you can have systems that don't aggravate those harms and those bad situations that they're in, and that allow the women to access, whether it's police or social services, whatever. I mean, one of the groups that was quite happy with the New Zealand law that hadn't been expected to be happy was the Salvation Army. Because the Salvation Army was doing a lot of work with street women, and they found that with legalization, it was easier for women to access their services and for them to find out where the women were. The women didn't have to hide and so on. So, you see that in the 5-year evaluation. It was interesting because I think the Salvation Army had been extremely leery of decriminalizing prostitution. Well, you can imagine why, but they ended up being on side and found it a bit easier to do some of the work they do, as did women's organizations. Well, I mean, I think there's general consensus that in most jurisdictions, all the authorities, be they be political or police, would much rather have more work off the street than on the street.
But if they're two different groups?
Well, they are, but you can encourage, like, for instance, escort services are almost never charged. And I mean, I still, after all these years, haven't figured out to what extent the escort services we have today are actually breaking the law or not. I think some of it has to do with how they advertise, and as I said, and the police officers in the audience could probably tell me a lot better. But in most places, police would rather just have a lot more escort services rather than have sex workers or customers on the street. Now, in Toronto, you get an interesting thing, which is you get street work, and especially the guys, the Johns, who kind of prowl the street, they often get sort of swept up and sent to John school. And one of my colleagues did an evaluation of the John school and found that a lot of the guys couldn't speak English well enough to manage phoning or going on the internet and sort of finding a sex worker that way. And many of those immigrant men also firmly believed that it was absolutely wrong for them to go on a date with an unmarried woman who, as they would say, she was somebody's sister or whatever, and they thought it was perfectly okay instead to go to a professional sex worker. So there were reasons why those guys were sort of on the street, and they were the only ones that were targeted, because I don't think customers of escort services are targeted. I think the number of charges for that must be like infinitesimal.
If I could go on sort of a more abstract level, more philosophical perhaps, I'm wondering how much traction, you've talked about this to lots of crowds, I imagine, with lots of people, so I'm wondering how much traction does the argument that prostitution isn't inherently deleterious or exploitative have? How do you put that argument out there, and how do you make it persuasive? And I was thinking, kind of like as an anthropologist, are there cross-cultural or historical examples of more benevolent prostitution that you might?
Yeah, I mean, a lot of independent work is not particularly exploitative. I mean, many of the women who are leading activists in the push, including the women who then successfully challenge the laws, are independent workers, and I know 2 out of the 3 of them, and they both have had independent, work lives, and they say, well, we turn down clients if we don't like them, and we're in control and we're fine. I mean, what I usually do is not talk about it abstractly, but show a documentary. This is what I do with my classes. It's a very good documentary on sex work in Vancouver called A Safer Sex Trade, and it just shows the different markets and the different relationships. So I often say, show this film, and then I say, look, there's no such thing as prostitution. There's many different markets, many different relationships. Many of them are really horrible, but in many of those cases, they're linked to other previous horrible events in those women's lives. Some of the markets and some of the relationships are perfectly all right. I'm not going to tell you how many, because I don't think we know. But I think it helps to take a more anthropological perspective and say, well, we use this word prostitution like it's one thing, but maybe there isn't one thing. Maybe it's like food or something. There's no such thing as food. There's like junk food, there's good food, there's all, there's no such thing as prostitution in general. There's always particular markets, particular economies, particular relationships. And, really, I mean, if unskilled women and Aboriginal women in this country were more empowered, it would be a whole different story. I mean, a lot of what gets attributed to prostitution is not necessarily strictly due to prostitution. So, I mean, it would be silly to sort of paint a romantic picture of these great independent women who run escort services, because they do exist, but there's probably not a huge number of them. But the fact that they exist, I think, is significant. And can you have a law that covers all of this?
How did the New Zealand model speak to human trafficking? Because a lot of people suggest
Yes. It was interesting because some people thought there might be some increase in trafficking because if brothels are legal and so on. But it wasn't the case at all. I mean, it's not the best test case because immigration into New Zealand is highly, highly restricted anyway. And it's a small country. It's not like a place that people sort of flow through on the way to other places. But actually, with trafficking, last year I read a doctoral thesis done at the University of British Columbia Law School by a high-ranking former RCMP officer who was actually the head of the first head of the Joint Immigration RCMP Task Force on Trafficking back in 2005-06, because the trafficking law was, it's older than the Tory government. It was Irwin Cotler's thing. So he said he and his, and this isn't a thesis, so I'm not revealing any secrets. He and his colleagues spent $30 million going around the country trying to find cases of trafficking. So what they would do is go to the local police and say, okay, you've got this and that, and this and that. You've got this case of living on the avails, and this case of this and that, body house case, whatever. Is there trafficking? There's been, I think, 6 prosecutions under the trafficking law after those $30 million. Something like that. I mean, there may have been some this year that I don't know about. And most of them, in fact, all of them except one, were things like Aboriginal woman from Nova Scotia moves to Toronto, and then she ends up with a pimp, and the pimp is charged with trafficking. It's not what we think of as trafficking. There was one case of a Chinese woman, but it turns out the trafficker was her boyfriend, and she had a cell phone, and she was going out to all these community meetings. She was not like locked away in some basement. And she at one point decided to go to the police, and then they charged him with trafficking. And so the conclusion was, not just in that study, but there was another study that I read, published last year too, that said sometimes trafficking is used instead of living on the avails. It's sort of easier to use, and it has heavier penalties and so on. But I think to focus on trafficking is, at least in Canada, I mean, I think in places like Poland or Germany, it may be a different story, because there are a lot of Eastern European organized crime groups that are, I mean, I don't know enough about it. But in Canada, I think trafficking is not a huge problem now in that classic sense of bringing women from other countries. And in this study, one of the people was asked, well, why isn't there more trafficking? They said, well, why would you bother to try and fool immigration and do all of this when there's plenty of poor women all through Canada who are Canadian born who can be exploited much more easily. So, trafficking I think is somewhat of a red herring in the Canadian case, although as I said, it may be a huge problem in other parts of the world. And I mean, this RCMP guy also said labor trafficking is actually much more prevalent than sex trafficking, but it's not targeted nearly as much. It doesn't have the same amount of resources, behind it. So he seemed to be more keen to go after labor trafficking.
There's no question from the audience. Maybe you allow me to ask it myself.
Oh, of course.
I'm somewhat familiar with the discussion around these prostitution laws in Germany, because they came in 2010 and they have been quite controversial.
Yeah.
And one of the consequences was or has been that along the border with France, for example, there are a lot of new and very large brothels.
Yeah.
Because in France it's illegal, but it's very easy to cross the border.
Yeah.
Do we have concerns like that here? If there is sort of a disparity in legislation between Canada and the United States?
Oh, sure. I mean, that might very well happen, but there's a reason why the city of Windsor started to license escort services. We're the first city in Canada to license escort services, and that's because there was an awful lot of traffic across the Detroit-Windsor Bridge anyway, especially after the casino opened. So, I mean, it might be more visible if the businesses are more legal, but I expect, it probably has to do with local policing strategies too, because I have no idea whether the police in Detroit bothers with prostitution or not. The police in Detroit are all, sort of losing their pensions, and they're probably not too worried about things like this. But I mean, there's a lot of that back and forth anyway, and I mean, Niagara Falls and Windsor are major prostitution sites in Ontario, And it's not because of the local population, it's because they're right across the border. So I think there's a lot of that anyway. But it is true that, I mean, it might be good to regulate the size of businesses and not allow the kinds of huge places they have in Germany, you know, because I imagine too, working conditions are probably worse, you know, the more industrial the place sort of gets. Yeah, but I guess, you know, the thing is all this is going on anyway. And it's the same with gambling. I mean, as soon as you change the laws about casinos or gambling, people will sort of go across the border, at least in those parts of Canada where it's easy. I suppose that's something you don't have to worry about in Regina too much. Not too many people in Montana sort of wanting to cross the border anymore. I mean, maybe it happens, I don't know.
So maybe this is a good point to thank you for a wonderful lecture. I think that everybody else really fascinated by the richness of the information, the ideas that you have given us. And I particularly like the idea that the detail, the devil is in the detail. And that well, it's also true for lawyers and for many academics. So thank you very much for the most entertaining.
Okay, well, thank you. Thank you. Oh, well. Thank you so much. Oh, well, I have my bag here too, so, but, you know.